Well, good afternoon, everyone. At least it's probably afternoon for a lot of us. My name's Rob Murray. I'm Treasurer of EMLO. Welcome to today's part 2 of our seminars on sustainability. EMLO is probably the leading international organization of its type with a long history of discussing and to tackle difficult issues thrown up by European law and regulation, often focusing on competition law, but increasingly focusing on environmental and sustainability issues, and in the case of this seminar, putting the two together. So the way we're going to run it is I'm going to actually do a very quick run through of some of the key points from yesterday's seminar for the benefit of those of you who weren't able to attend it, and to give us some context from the industry of how today's seminar fits in, because we are going to actually dive deep into the key competition law issues, and my colleague Matthijs Visser will introduce our distinguished guest speaker, Theon Dijk from the Netherlands Competition Authority in a moment. But firstly, yesterday, I think the key takeaway from yesterday was that action is needed quickly, and that the action to be effective requires a multidisciplinary expertise. It's not just loyal policymakers or economists, or importantly, not at all just them, but importantly, people who actually know how to make things work, who can provide the technical solutions, and people who know how to implement these solutions and get people to basically get together and sort this crisis out as soon as possible. And within that, there was a lot said about the global nature of shipping, at least part of shipping. Obviously, there are many types of vessels, many types of trades, but it's fundamentally a global industry with the potential to have global regulation. But then there are many different views on whether the IMO, for example, is doing too little too late, or whether the EU is doing too much too soon, what that regulation should look like, how it could be enforced. And then you have an industry which is regarded as a transitional phase industry, which means that you have to manage the process of going from fossil fuel to no fossil fuels and no greenhouse gases through a complex transition on a technology neutral basis, which raises all sorts of questions about provision of infrastructure to go with the different technologies as the industry and policymakers work out which are the best solutions. Everyone seems to agree that you need some market-based mechanisms. You need a price for carbon. Obviously, we have a price for carbon, but the emissions trading system, for example, of the scheme has not been until very recently anything to do with shipping, and that's only a partial part of the picture. And of course, we all know that shipping is one mode of a very complex supply chain. And the people using that supply chain may not consider it to be, composed of separate entities. They may require that the supply chain as a whole deliver them a net zero solution, which requires shipping to engage throughout that complex supply chain. So there's going to be no one size fits all. And at the end of all of this, there's a vast bill that needs to be paid. Money needs to be raised. We heard yesterday about attempts at the EU level to make sure that there was at least some way of trying to define what activities should be properly regarded as green and what remain brown. So that's a whistle-stop tour. That's the war we're in. I'm going to hand over now to Matthijs and look forward to hearing from Theon.
Thank you, Rob. And welcome everyone. I just take this opportunity to shortly introduce Theon van Dijk. I've known Theon already for quite a long time. I was basically his successor at RBB Economics. When he left, I joined RBB, and that's already 70 years ago or so. So that's already quite a long time. But Theon is speaking today in his capacity as the chief economist of the Dutch Competition Authority, ACM, which he joined on the 1st of October 2019. So a little bit less than 2 years. And I would like to hand over to Theon to explain, in particular, the guidelines that ACM has issued not too long ago on how to deal with sustainability in agreements between competitors.
Yeah, thank you, Matthijs, and thanks for the invitation to speak here and to be able to set out our sustainability agreement guidelines. Actually, when I joined in October 2019, this was one of the first jobs I had, me and my team, to make an economic contribution towards the update of our sustainability agreement guidelines. They are still in second draft. We published the second draft in January this year, and yeah, in our view, it's an example of how competition law could be more open, more permissive towards sustainability agreements. It is still a draft, even a second draft, because there is an ongoing discussion now in Europe about how to assess these types of agreements. And in the end, the discussion will be clear. The Commission will make a decision. I will come to that later on. And then we all comply to that line. It is the Commission is the guardian of the European Treaty, and the national competition authorities will have to follow that line. I will take questions in the end. It seems to me that is most efficient. The next slide, please. So my talk will be brief. I will first say something about our motivation to update the guidelines. Then I will go into the details of the exemption conditions to the cartel prohibition and explain where our approach is different from the more traditional approach. Then I will say something about sustainability benefits and how to quantify, how to monetize them. And then I will end with the state of play with respect to the discussion on this type of agreements. And the motivation. At ACM, we had the feeling that almost a notion of government failure. People often talk about market failures, but here we see almost a government failure in the sense that governments, well, at least in the Netherlands, but I believe it's a broader thing, are not active enough to take measures in the area of climate change and sustainability more general. And in our view, it would be helpful if private action would be able to complement more than now government action. And one possibility to do that is through competition law. It's in the bigger scheme of things, it's quite modest, a modest contribution we can make at most, but still, we believe it's important to also from competition law make this contribution. And this contribution can be that to take away the perception that competition law is an obstacle, but also sometimes companies use as an excuse competition law not to be more active in this area. And in the Netherlands, it's in particular perceived as an obstacle, and that is also due to two decisions that ACM made in the past. In the Chicken of Tomorrow case, perhaps you've heard of it, I will not go into detail here, and the coordinated withdrawal of coal-fired electricity plants. Our assessments of those two cases was that in those two cases, it was not a good idea to have cooperation. even though it is in the area of sustainability, because the cost, or better to say, the benefits were not large enough to make up for the costs. But that is now the perception of ACM in the Netherlands, that we are very strict in these sustainability agreements. And that is also part of the motivation that we wanted to correct this picture and signal that we are open. So the next slide, please. So the cartel prohibition, I was told that there are many competition lawyers listening. So this is nothing new. Article 101 of the European Treaty is a cartel prohibition. We have an equivalent of that, an identical equivalent in the Dutch Competition Act. And 101.1 says that, that cartels are prohibited. But there are exceptions possible, and the conditions for those exceptions are identified in paragraph 3 of 101. And there are 4 criteria. The first one is the agreement should offer benefits. And here already, in our guidelines, we say that sustainability benefits are also genuine benefits. So it's not only cost benefits or product quality benefits. Benefits can also be in the area of sustainability. And within sustainability, you can say there is more subjective sustainability, and then I'm talking about animal welfare or child labor, more social sustainability. But we would regard those also as benefits under 1. There are also ways to quantify it and to weigh them against possible cost or price increases. Another type of sustainability is more collective sustainability, and that is more in the area of reduction of CO2 emissions, other greenhouse gas emission reductions, air pollutants, biodiversity, that kind of thing. We label that group as environmental damage agreement in our guidelines. The second condition I will come back to later. It's the fair share condition. And that is where we differ from the traditional interpretation of 101.3, but I will explain that in a bit. The third condition basically says that cooperation is necessary in order to obtain the benefits. And in our guidelines, we explain under what circumstances we think cooperation is indeed necessary, and unilateral action would not be possible. And that is, there should be first mover disadvantages. If you are competing with other firms and you would be the first one to have a more sustainable product or more sustainable service, and the others would not, then it's quite likely that your customers switch to a large extent to your customers, and that means that you're not very inclined to be the first one to have more sustainable products. So there we see a possibility that is really needed, that cooperation is really needed. If we all agree to introduce more sustainable, more expensive products, then you don't have this free riding of customers that switch to your competitors. And another possibility where it is necessary to cooperate is if there are fixed costs associated with introducing sustainability, more sustainable products, and you need volume, joint volume to recoup those fixed costs. That is another circumstance under which cooperation may be necessary. And we set those out in our guidelines. And the final condition is that competition should not be eliminated substantially. And that means that well, if all players in the market are part of the agreement, then it could be that there's not much competition left. Another possibility is that the cooperation is dealing with factors which are only a small share in the total cost of the product or the total price of the product. Also in those circumstances, one would expect that competition is not eliminated. The next slide, please. Sorry. So the fair share is really the heat of the debate at the moment. And it's a fair share of cooperation benefits to consumers. So the traditional approach is that consumers in a market should be fully compensated. And by that, we mean that the price increase, which is the result of the agreement, it has to be paid by consumers. And that price increase must be fully offset by benefits to those same consumers. So, so this is also sometimes called the full compensation principle. So the consumers who pay for the price increase should also be compensated, fully compensated for the benefits that are resulting from the agreement. And this means that benefits to non-consumers, so outside of the market, do not count. And the novelty in our approach is that we think in some cases out-of-market benefits should also be taken into account in the assessment. And we have some limiting principles about when that should be the case, to which I will come back in a minute. But this means that, well, there are costs, price increases as a result of an agreement. And those costs must be offset by benefits to consumers and non-consumers. And that means that the net result is more often positive compared to the traditional approach. And in that sense, this new approach is more permissive towards a sustainability agreement. And the next slide, please. We formulated some criteria, and if these criteria hold, then we believe this broader interpretation of fair share is applicable. First, the agreement must reduce environmental damage. So we are not talking about social sustainability, not about animal welfare or child labor or something like that, but really environmental damage in the sense that that emissions cause external effects. They affect more broadly a group, a society, than only the consumers. And one can think of CO2 emissions, NOx emissions, ammonia emissions, and really the common thing about these environmental damages is that there is one type of economic problem underlying, and that is what we economists call the tragedy of the commons. If there are common sources like air, like soil, like water, there is a tendency to overuse those. And so this is the type of problem we want to tackle with our more open approach. The second condition that we have formulated for our fair share condition is that the government has set a goal for this reduction, and this goal is not binding, because otherwise you would not need an agreement. If there's a law, a binding law, then everybody has to comply with it, and you don't need to cooperate. So this is, what we have in mind is really what is beyond what is really required by law or by regulation. And well, there are two reasons why this is one of the conditions. The first is, we see it as a some kind of democratic legitimacy as a competition authority. Normally we don't do redistribution. That's not in our mandate. And here, by choosing a more open approach and the fact that consumers pay for and are not fully compensated and the benefits go to all, that you could see that as some form of redistribution. And we are only comfortable doing that if there is, if government has set a goal, and that can be an international treaty which is not yet implemented, or it can be a policy intention, or it can be a judgment by a judge. Those are the type of things we would be looking at if we would assess a sustainability agreement. The third condition is that the proposed measure should be cost efficient. There should be not other measures possible that are more cost efficient than the one that is proposed. And this includes really government measures that are likely to become present in the near future. We would also take those into account when assessing this condition. And then the final condition, of course, is that the net of the total benefits and the cost should be positive. So not only to consumers, but to the whole of society. And if those conditions are met, and they have to be met, all of them, then we in our view, we can give the green light to a sustainability agreement. Okay, the next slide, please. Well, one of the practical difficulties is if you are entering such a cost-benefit analysis, including sustainability benefits, how do you quantify that? How do you monetize that? This is something that the Commission and other competition authorities have also asked us. I mean, the plans are great, but how can you put this into practice? And really, it's not that difficult. I'm a competition economist, and in competition economics, we are not used to doing this, but there's a whole branch of economics called environmental economics, and there it's pretty common to quantify sustainability benefits. There are methods. And if you are interested in this, it's really a social cost-benefit analysis, which are routinely carried out by many governments. This is then in the area of environmental. It's an environmental cost-benefit analysis, and a publication which is quite interesting is from the OECD, and there they explain how to go about carrying out such a cost-benefit analysis. There are various methods for valuing sustainability benefits, and we joined forces with the Greek competition authority, and we commissioned a technical report from 3 academics, and we asked them to make an overview of all the methods that could be used to value, to put a number, a euro number or a dollar number on sustainability benefits. You can find this report on our website. Just to dive a little bit deeper, but not too much given time constraints. But when there is a government goal, which was one of the conditions, it is likely that there is a shadow price estimate available. And what is a shadow price? A shadow price is an estimate of the social valuation, so the value to society of the environmental damage caused by 1 unit of emission. For example, in the case of CO2, it has been estimated that 1 ton would cost 57 would be valued by society at 57 euros a ton. And in the case of NOx, that is much more. That there are different methods to come to such numbers. Broadly speaking, there are two. The abatement cost method, and that is what it would cost to prevent or to create a reduction of emissions, to use another technology, or for example, in your sector, I understand slow steaming could be a way to reduce CO2, and that would be a cleaner technology, so to say, which would fit in the abatement cost method. Another possibility is to try to estimate the damages that are caused by a unit of emission. And for example, in the case of CO2, what it would cost in terms of health to people, in terms of buildings. Could be that maintenance costs are higher if CO2 emissions are higher. And if you do that in a systematic way, and you make an estimate of all the damages that are caused by 1 unit of emission, and you add those, and the sum would then be the social value would be the shadow price of CO2, for example. And just to illustrate, the next slide, please, how this is done in practice. There is a think tank or a consultancy in the Netherlands called CE Delft, and they publish on a regular basis shadow prices, which they calculate. For example, for CO2, the first line, the first row, they have a central estimate and a lower and an upper bound. And as far as we are concerned, the Dutch Competition Authority, we would accept those numbers that are calculated by CE Delft in any calculation to substantiate a sustainability agreement. It's not necessary that you estimate yourself shadow prices. These can be taken from other sources. And this is an example of a source in the Netherlands, but there are many sources in many countries. And in this way, it becomes very practical, because this would be the basis for the extent of sustainability benefits in euro terms, and the price increase, the expected price increase of an agreement. One can calculate by estimating the additional cost that an agreement would lead to, and well, then you already have the basis for the trade-off. I would like to end with the EU discussion. In Europe, there is an ongoing discussion between the Commission and various competition authorities in Europe. To be honest, there are two camps. We ACM are in the more open camp, so to say, together with, for example, the Greek. But there are also competition authorities which are more critical and which don't want to be as open as we do. And the arguments or the considerations that they put forward is that it could be a slippery slope if you use competition law for sustainability purposes. What if there are other public interests than sustainability, and it would be a stretch, it would be an inflation, so to say, of competition law if you would use it to serve also a lot of other public interests. So that is one argument that is put forward. Another is that if you create more opportunities to private action for sustainability, then you're crowding out, you're making less likely that there is public action. And public action is more efficient in achieving these goals. So that's also an argument that is put forward. And the final argument that we often hear is that it's too difficult. The cost-benefit analysis, including sustainability benefits, is too difficult. And yeah, this last point, that was the main aim of my talk here. That is, in our view, not a genuine concern, because it is well possible to quantify. As I said, the discussion is ongoing. At the moment, the Commission is preparing a consultation of the horizontal block exemption regulation in R&D and specialization. And it's preparing a consultation for the guidelines on horizontal cooperation. And the last I heard is that they are planning to open the consultation in September. And then it will become clear what the position of the Commission will be, because then they are forced to come up with a text that is then consulted, and in this text they have to make a choice whether they want to be more open or whether they want to be more traditional towards sustainability agreements. And I would like to end there.
Well, thank you very much, Theo. That was fascinating, and you know, congratulations on the initiative. If I may, I had a question. You said that where a government had set a goal which was not binding, then you could step in, and it just occurs to me that there's a possibility that there will be binding goals or targets, but that actually there's very little detail about how you're supposed to achieve them, and that therefore there's a lot of, you know, I can imagine the politicians not wanting or being able to be particularly prescriptive. So you have to achieve X, but it's up to you how you do it, as long as you, and presumably that sort of hybrid is where you would still welcome private initiatives, because almost by definition, if the implementation is not specified in detail, then someone has to work out how to do it.
Yeah, I tend to agree with that, because then there are still benefits to cooperation. So I think in those cases where indeed the goal is not very precise, or or the end date is not very precise, then there is still scope for our broader view towards assessing this. If there is a very clear goal and also a clear date, then of course, yeah, you can still cooperate cooperate and in order to be more sustainable. But then the only thing is that we would be not looking at out of market benefits then if we would assess that. So it's not that you cannot cooperate in those cases, but we would then take the traditional view again.
I also had a question. So one of the examples from the past you mentioned was this withdrawal of coal capacity or the buyout of coal capacity in the Dutch market, which kind of prompted the ACM, you could say, to explain, okay, what is possible? If this is not possible, what is possible? What is a cooperation agreement which fulfills these conditions? Maybe maybe it helps to highlight why do you think that the cooperation agreement did not qualify for an exemption, and what should happen to such an agreement in order to qualify for exemption if you would follow the guidelines that ACM has today?
Yes, there was indeed this case of a coordinated withdrawal of coal-fired electricity plants. We made an assessment of that. We used shadow prices also already in that case. But the main point there was that there would be CO2 reductions, but parties were not prepared to give away or to destroy the rights, the CO2 emission rights that they had. So our assessment was that the emission rights that they had, they would sell outside the Netherlands or so, but it would not therefore lead to a reduction in CO2. And one of the requirements ACM put to the parties was to withdraw those rights or to destroy them, and they were not prepared to do that. And that was the key reason why ACM did not give the green light there.
Yeah, and I think if you think about shipping, right, which is a global industry, that is kind of, in that sense, it's a useful example, in the sense that if something would be done in shipping through voluntary cooperation between shipping firms, then of course leakage of the benefits would be a potentially big issue, right? In terms of an Article 81.3 type assessment. Do you agree with that, Theon?
Yes, no, I completely agree with that. Because if it results in leakage, then you don't solve the problem, or you don't contribute to it solving the problem. Yeah.
Right.
You have two questions.
We have a couple of questions. Question from Mark Clough, which is, how do the shadow price estimates compare with the EU ETS allowance prices?
Yeah,
that's quite a specific question.
Yes. Well, I happen to have a look at it this week, so I can answer that. The ETS price at the moment is lower than the CO2 shadow price as estimated by CE Delft recently in 2020. So the shadow price, the actual shadow price is higher than the ETS price, which would mean that the benefits to CO2 reduction as a result of an agreement, the benefits would be valued higher if you use the shadow prices rather than the ETS tariffs.
Okay. Which is in fact another way of saying that the price of CO2 rights doesn't reflect the true cost of CO2.
Indeed, and I am not in a position to even indicate what could cause that. I don't know why the ETS tariffs are too low, but they seem to be too low.
Well, that's so there's another question from Jim Corbett, which is a more complex situation, but basically what happens if you have effectively two competing shadow prices, or rather two prices that need to be taken into account. So you have, for example, the price for CO2 that you're trying to reduce, but you also have a price for how you're trying to reduce it. So here, the example he gives is ammonia, and he says it's difficult, if not impossible, to compare long-lived greenhouse gases with short-term pollutants via shadow prices. So I think he's looking for a sense of how do you tackle that kind of more complicated issue. Do you just simply get the prices off, or do you have another methodology?
If through one agreement the emission of various substances are being reduced, it's just a matter of adding up. If as a result of an agreement, some substances, the emission increase, others increase, then I think, I don't have experience with this, but I think it's just a matter of first monetizing each individually and then sum them up or subtract them. I think that's possible. That it's not that complicated.
Okay. that I think is a good place, though, to go on. So thank you very much indeed, Theon, for the most interesting presentation. I understand you may have to leave a little earlier at some point, so thanks are made now. We're now going to move on to a series of case studies, hypothetical or not quite so hypothetical case studies that Matthijs and I have developed. And I'm going to hand over to Matthijs because he's in command of our slides. And by ours, I mean the ones that Matthijs drafted and I changed very little.
So I will try to start sharing my I have to say slides. Yeah, so the idea of this part of the session is really to have a conversation, and please others feel free to chip in if you want to take part in the conversation. But in principle, it will be firstly between me and Rob to have this conversation. But the question is, considering the challenge for the sector to reduce CO2 emissions, and considering the types of agreements that Theon explained may actually, with some flexible approach to competition law, or rather an approach in which kind of external effects are included in the customer benefits analysis, what is possible? I mean, there is clearly a need, and I will move to the next slide. There is clearly a need for the shipping industry to do something, and I think that also came out of yesterday's session, as the sector is responsible for 2 to 3% of global greenhouse gas emissions. So that's quite a bit actually. And if you want to go to net zero, as it's sometimes called, by 2050, and if you also know that a lot needs to be done actually in the next 10 years, then the question is, okay, where are we with regulation, and what role is that to play potentially for agreements between firms? And I guess the question is there kind of a supplement there that is available and could be used to the advantage of the environment, basically, and therefore the advantage of the world? I think, although this is obviously a contentious area where I may step on some toes, but I think the overall consensus is that the IMO measures that have been agreed recently, so this is in the context of the UN, are barely sufficient to keep greenhouse gas emissions stable, and actually may even grow if containerized trade grows with world market growth. I think it's also fair to say that the EU measures, which are due to be announced, do provide some solutions, but at best provide a regional solution, or a solution that is aimed at the European contribution, so to speak, to a global problem. But essentially, we're still talking about a global issue that needs to be tackled by a globally active industry. We also know that even if you consider regulation as your first best option, basically, to tackle environmental issues, what we also know is that effective regulation at the global scale is difficult, and is also likely to be rather slow. I mean, we've seen the news on trying to get to a global solution on tax avoidance, for example, and this seems to now get some traction. But this has been discussed for over decades, I think, how to close loopholes in a global tax system. And it's still not clear whether something will happen. So regulation on a global scale and enforcement of such a regulation without a global regulator or enforcer is likely to be difficult. So regulation may not be, at least not for the shipping industry, the overall answer to this issue of greenhouse gas emissions. Then, of course, there's individual actions by market players. I think, and that I think was also part of Jim's presentation yesterday, I think the industry actually understands their responsibility and understands that they need to play part in, that they need to be part of a solution rather than trying to be part of a bigger problem. However, individual action by market participants is unlikely to be sufficient to meet the Paris climate goal targets, climate agreement targets. So, for example, and I think that was mentioned yesterday by the Speaker of Transport and Environment, LNG as such, as an alternative fuel, may result in reduced emissions only by so much, because it's still, of course, in the end, a fossil fuel. It may be a bit better fuel than the bunker oil that is typically used and less polluting, not only in terms of CO2, but also in other aspects. But you're not going to go to net zero if the whole shipping fleet would be replaced by LNG powered vessels. I think another development we see is that customers may actually, the market may demand more green shipping. I think there was some news of Maersk concluding an agreement with a customer which actually needed to be greened, so to speak. At the same time, you also know that not all customers will demand compensation for CO2 emissions caused by transport of the goods of those customers. And I think ultimately, from an economic perspective, it is very unlikely that individual action will result in a sufficient reduction in greenhouse gas emissions, simply because without a global CO2 tax, externalities, i.e. the impact of greenhouse gas emissions on the climate, are not reflected in prices. Therefore, prices do not reflect true costs and continue to give the wrong signals and the wrong incentives. And that's where potentially the questions come in relation to also the framework that Theon has set out. So if regulation falls short, if individual action by market participants is unlikely to be the solution, what role is there for green cooperation agreements between shipping lines? And I pause here and ask Rob whether he wants to add something at this stage or whether he lets me continue.
Well, I think it might be worth, Matthijs, just reminding ourselves, and not everybody who's listening is perhaps a competition lawyer, but it's worth reminding ourselves a little bit of what is the context for competition law. And sometimes this discussion seems to be almost a kind of, well, you either have regulation or you have competition law. But in fact, in most markets, you know, regulation and competition laws go hand in hand. They're there. They're not alternatives. You have to deal with both of them. And basically, that, you know, there are well-known differences. So regulation, you would expect to sort of have a forward-looking perspective of telling you what you can and cannot do. Competition law tends to have a backward-looking perspective of telling you when you've got it wrong. And then one of the important things I think to remember about competition law is, and particularly I think in Europe, is that it's just one of those areas where there are some really significant sanctions if you get it wrong. So enforcement by regulators, if to the extent that they pick the right cases and you know, investigate, etc., enforcement can have very significant effects. And under the modern system of competition law, you can't actually, in most places, you can't get a regulator to give you a cast iron guarantee that something you want to do is actually going to be permitted. And I'm not at mergers and acquisitions here, but just on the commercial agreements. So I think, although competition law may not be the sort of frontline tool to get things done, but the risk is that competition law is in fact potentially quite a considerable barrier for private initiatives which involve cooperation. And in the shipping industry, it's difficult to conceive of even, you know, even the unilateral actions of the largest players is not going to actually shift the dial enough. So the issue really is, and I think this is what's behind the ACM guidelines, is to try and change the perception that competition law is going to be a blocker, and that it actually stops people from even trying to talk to each other. And I know from our own practice that that is a real problem. You get sophisticated players together, each with their own in-house and external competition advisors, actually getting them to even contemplate talking about certain type of cooperation is a really tough battle. Partly because the fear of getting it wrong, of getting fined, of people like me in my day job deciding to pursue a company for damages because they have, for example, run an unlawful cartel or whatever. And against that is a very important aspect. But another important aspect is that not everything gets caught by competition rules. So yes, it's right that we focus on the sort of exemption type issue, but there may be ways of doing some things which don't get caught. There may, for example, be ways of achieving certain things in a vertical agreement that are simply not achievable in a horizontal one. And I make the observation that a lot of what I've read seems to focus straight in on, frontline horizontal cooperation between big competitors, but that's not necessarily the whole story. So I think helps us go into some of the other points and some of the other factors that companies might take into account in deciding whether or not to even talk in the first place.
Thanks, Rob. It's also my understanding, but Theon will probably not or otherwise confirm that indeed one of the purposes, you could say, of the guidelines is to kind of do a preemptive strike and signal to the market, we are not your stand in the way to come to agreements which are essentially good and are essentially contributing to solving issues rather than having the competition authority as a blocking institute. But maybe Theon wants to comment on this.
Yeah, oh, indeed. As I explained in the motivation part of my talk, this is one of the main motivations behind our update of the guidelines, and not to be perceived as an obstacle, and also not to be able to be used as an excuse not to undertake action. And I mean, I have focused on 101.3, the exemption conditions, but in the guidelines we also explain circumstances under which you do not fall under the cartel prohibition. That is also a way to be more open. And also, if you act in good faith and we find that it is still not allowed, then we would not give a fine. So that those are also elements to change the perception currently.
Yeah, because I think what is actually lacking are clear examples of agreements, voluntary agreements that actually fulfill the conditions of ACM. I think that ACM and other competition authorities, and maybe even the Commission, would actually welcome the opportunity to put those agreements to the test and actually go into a debate on the quantification of benefits, but also potential costs in terms of a loss of competition.
Indeed, we invite parties to come up with agreements. We are desperate to assess agreement, and there is a chicken egg because the Netherlands it's only a small country, and agreements often are relate to more countries. But in the meantime, since we published the guidelines, we have now 3 or 4 agreements that are put in front of us and which we are assessing at the moment.
Okay, thank you. So again, just to summarize, and we'll come to some potential examples for the shipping industry in a minute. But just to summarize, so why would firms need to go into, let's say, collaboration mode? It is to solve a first mover disadvantage for firms that take action, which is costly. simply because if you are active in a competitive market and you want to take measures that are good for climate, but are actually increasing your marginal costs, then the risk that you run is simply that your customers run away because you become too expensive. So you risk running your own cost base. You risk running to have to charge a price which is higher than your competitors, which would result in a loss of volume and a loss of market share. So very simply put, in economic terms, because external costs of pollution are not included in the price, individual actions to try and actually do that may fail, simply because as a result you become uncompetitive. So one reason to try and think about cooperation agreements to tackle climate issues is to solve this first mover disadvantage. I think other factors are also at play, whether or not which could contribute both to individual action, but I think also to collective action, which are the duties of boards of companies, and lots of them have now environmental standards included, I think, in also the way in which they report, but also pressure from shareholders and customers that invite firms to take more action on the climate front. And I think what we've recently seen in shareholder meetings of the big oil companies goes in that direction, actually. And then one, and I'm an economist, so I can't comment too much on this, but one interesting example or interesting recent judgment is a Dutch court judgment in which Shell is actually held responsible for its contribution to global warming and its duties to actually reduce emissions as a firm. I mean, this is highly contentious because it is, of course, a big question whether you can hold individual firms responsible to contribute to things which are essentially in the domain of the state. But at the same time, it does give a warning sign. And I think environmental groups in the Netherlands have already announced that they will start to litigate many more firms. And that may also have some repercussions for firms abroad. So it could actually be that not only something needs to be done to solve the first mover disadvantage, but also that there will be a lot of pressure on firms to start taking action, simply because not only their own responsibility, but also because of pressure from shareholders, customers, but also potentially litigation. Rob, do you want to add something to this?
Well, yeah, I think another aspect of it is actually the whole financial services industry and pressure from the people who actually have the capital that's going to be needed to do, you know, green investment, but also any kind of investment. The idea that people are beginning to wake up to the notion that the valuation of some businesses is perhaps fundamentally wrong. I mean, many years ago, there was an issue, and I can't remember which oil major it was. I think it might have been BP, in the other direction, where it was found to have misstated overstated its oil reserves. And at that time, the oil reserves were considered to be an asset. It's possible that the situation has shifted to the point where those are no longer considered to be an asset and might actually be connected with liabilities. So ultimately, it is you know, money talks. And I'll say one other thing. In my experience, I've just recently come across the launch of a litigation fund, so a fund that seeks to fund cases, claims, etc., with a specific green remit. So not only are there NGOs and other not-for-profit organizations who have been funding environmental litigation for many years, but here's a commercial organization that seems to think that, you know, a green tinge at the very least to its activities might be a good idea. So the whole money talks side of all of this is extremely important, as is whether or not, the very tricky issue of greenwashing, which is way outside the parameters of this debate, except to say that if environmental considerations are becoming a competition parameter, then greenwashing is fundamental, because if people are being misled about the actual environmental claims, the reality of those claims, then that competition based on the consumer's desire to do good and make green choices will be, tragically distorted in other ways. There's another externality that isn't reflected in the quality parameter, if you like.
Yeah, before we move on to the examples we've worked up, maybe one short question to Theon, if he still has a bit of time, because I mean we've had a debate also in the Netherlands on the guidelines of ACM, and I think one of the comments from some economists is that the approach of the ACM may actually result in greenwashing, and maybe you could comment on that. I mean, I think the logic of individual action increasing marginal costs, making you anti-competitive and uncompetitive, is a clear logic why you would end up in collaborative agreements. So where does this potential risk of greenwashing come from? This idea?
Well, the voice that we heard in the Netherlands is that a concern that when competitors agree with each other, that the profit that is resulting from the agreement is maximal, but the sustainability benefits are minimal. And well, that could be a genuine concern, but I believe that in the framework that we have set out, we are very careful in assessing, and we understand this concern, but I think the limiting principles that we have identified and which we have set out should provide enough assurance. And I mean, at ACM, I think we have the knowledge and the expertise to assess when an agreement is really genuinely meant to reduce emissions and when it's greenwashing. Perhaps I'm overestimating our capacity, but I believe I would see it if there's something wrong.
Yeah, so we touched on the why, then the how, and I think Theon made a very clear presentation on how a competition authority like ACM, but the same could, apologies, obviously apply to competition authorities around the world, including European Commission, is simply a weighing of the pros and cons of a particular agreement in terms of, okay, what are the actual benefits of this agreement in terms of a reduction of, in particular, CO2 emissions, and perhaps even the more difficult part is what are the costs of these agreements in terms of a loss of competition. So basically, we thought, okay, if Rob and I can think of 4 examples of collaboration agreements that the industry could think of, then logically the industry must itself be able to come up with even better examples that they could actually achieve. So in that sense, I would be also very interested following a short discussion on the 4 examples we could think of, why this could not be done. And I think what I see no reason, but maybe Rob may think differently, but I see no reason why it would not be good for the CEOs or the operational people at the shipping lines to bang their heads together and to actually start thinking about this and think of something which they actually could put forward to the competition authorities to check. But Rob, maybe you may have some practical difficulties associated with that.
Well, I think a lot of it is perception and the tendency of lawyers, particularly lawyers who have sort of compliance risk roles, to simply want to minimize risks at all times. So the issues that arise, and we're dealing with these in my firm at the moment, is just this overwhelming sense of not wanting to do anything that will get anyone into trouble, and a lack, if you like, of it's the chicken and egg point that Theon said, which is everyone wants to have the guidance from the authorities as to what they can do, but the authorities can't give that guidance until they've seen an actual agreement. So there's a kind of Mexican standoff, which we think, I mean, Matthijs and I think it's important that someone basically gets a grip and says, well, let's have a go. If our motivation is bona fides, if, for example, you could contemplate having a trusted third party involved in those kind of conversations, which could confirm to a regulator that they really are serious about environment and not about price fixing for commercial gain. There's all sorts of practical ways of sort of reducing the barriers to this, but fundamentally, the barrier is the fear that if you get it wrong, it could have bad consequences for the business. So you need a sort of confidence building measures, and I think the guidelines are part of that, but not enough yet. And private practice lawyers, I think, need to be prepared to stop a bit more and give advice which, without being misleading, is saying, well, reminds people that taking the least risk option is not necessarily the right thing to do if the rewards, for example, are very great. You basically normally have to take more risk, more reward, and this might be the same situation. But I think we keep on talking about our the examples we come up with. I think we should actually talk about one or two of them in concrete terms. So why don't we spin on to that?
Let's do that. So we thought of 4 examples. And the first one would be to have a climate crisis cartel, where the shipping lines would put a CO2 surcharge on each container shipped, put the proceeds in a fund, and to buy out the most polluting vessels, which would then be combined with minimum standards for new vessels. And what this type of scheme would achieve is to phase out the most polluting vessels through this surcharge. At the same time, of course, such a scheme would increase marginal cost and price of the shipping lines. So either through a surcharge, which is kind of similar to the air cargo surcharge we have seen, and for which the European Commission actually imposed fines, or indirect through a pass on of the cost increase. I think a second potential cost of such a scheme would be that because you take out polluting vessels, it would be reducing overall capacity in the market. And we know that in particular in container shipping, there is a strong link between the supply of capacity, between supply and demand in determining prices. So the question is then, how would you quantify such costs or quantify the impact of such a capacity reduction? I think a similar type scheme would be, we know that in the plans of the EU, shipping will be partly put in the emission trading system, but as far as I could see, it would not be. It would certainly not be on a global scale, and it may actually only apply to intra-EU transport, or in any event only to transport that touches upon ports in Europe. But what you could also think of is a similar type of surcharge on each box, and then the proceeds being used to buy CO2 emission rights in the market. So it's some sort of voluntary voluntary participation to emission trading system by simply buying CO2 rights to compensate for the CO2 emitted, with some interesting incentives, I think, which follow from that, including an incentive to emit as little as CO2 as possible, because that basically means that you have to contribute less in buying those CO2 rights in the market. Again, a potential negative of such a scheme would be an increase in marginal costs and hence price. So there would be a price effect, a likely price effect associated with this. I think two other examples, and this has been touched upon before, would be, for example, an agreement to slow steam. This has been mentioned already yesterday also by the speaker for Jacob Armstrong, the speaker for Transport and Environment, which would be an agreement to reduce the speed in order to reduce emissions. And the same research institute that Theon mentioned that calculates shadow prices, in fact, did a study to estimate the benefits and costs of slow steaming. Well, firstly, there's a clear relationship between speed and CO2 emissions. A 10% reduction in speed results in a 19% reduction in energy required. I think yesterday there was a question in the seminar whether this reduction is net of the CO2 emissions resulting from building additional vessels, because logically you need to increase the number of vessels in order to carry the same volumes if you're going to reduce speed, because the whole network is simply operating at a lower pace. But I think it was net. And then the question is only, I think, okay, where do all the vessels come from? How do we get to a sufficient number of vessels to increase capacity in order to potentially reduce the price effects? But because logically, if this has a large impact on available capacity, it would potentially also have a large impact on price. But this is a third way to think about it, yeah?
Yeah, and it occurs to me also that given the skepticism some people have over LNG as even a transitional solution, it may be that this is a better transitional solution in terms of greenhouse gas emissions. I don't know, but even though it doesn't involve moving away from bunker fuel, because I guess that's something which the mechanism that the methodologies that we've been discussing could be used to assess. So I was just wondering whether I couldn't really see Theon's face when we led in with the, oh, let's just set up a cartel to sort this whole thing out with private standards and all the rest of it. But we were kind of deliberately sort of going for something which was quite red meat, its debate. And the question really is, if that is done, but with a clear and sole environmental objective, is it the kind of thing which can make any kind of headway in the light of the sort of traditional views of competition? And I'm putting you on the spot a bit, Theon, but it'd be interesting to know whether you would just say, look, that's just too many difficult issues in one thing, or whether it's something that could at least be talked about.
Well, talking is always possible, and that is also what we offer in the guidelines. So if parties are in doubt and they need more comfort, we can together with them sit together and try to help designing a scheme. For this particular example, there are quite a lot of potential concerns. So it would sooner be an uphill battle than rather than wind in the back, so to say. But that is just shooting from the hip, so to say.
Yeah, and I know I was very unfair, but I mean, what you introduce is this relatively new idea of the what's often called the regulatory sandbox type idea in the context of regulation, where instead of the Mexican standoff, people get into a room and start throwing the ideas around. And it seems to me that is potentially a very important aspect of any attempt to deal with issues as complicated as environmental sustainability. But it can be still something that people are reluctant to do. And interestingly, I noticed that in the UK, there's been a recent attempt by Google and the CMA to come up with a way by which Google can do what it wants to do in relation to privacy policy. And that was done through a regulatory sandbox, but actually the CMA really didn't like what Google had already started doing before it engaged with the CMA and sort of issued a publication saying, well, actually, we think you've already been breaching competition law. So the process in the competition context is not without risk. So we get back to our catch-22. But in practice, I think what you probably need to do is to start at the other end of the spectrum, and with something that is far less contentious, perhaps a single issue, and see and build up from simplicity and what things can be combined. So we have people looking at, for example, establishing some minimum private standards, which are not the end goal, but they are an attempt to get things moving in a particular area. And that, I think, still raises quite considerable issues, but it's probably a better place to start than our deliberately provocative full-fat cartel.
Yeah, then I think maybe a bit less provocative is the fourth example.
Yeah,
I think Transport and Jacob Armstrong yesterday said essentially that hydrogen is the future, because that's the only true, let's say, potential green fuel. In the sense that you're not emitting CO2 if you use hydrogen, which is based on sustainable energy sources. And then, of course, you have a problem with infrastructure, because in order to have hydrogen-powered vessels, well, A, you need the vessels, but B, you also need considerable infrastructure in ports and elsewhere to facilitate this. And here you have some interesting examples, I think, of, and I put a clipping from the Financial Times 2 days ago, where you actually see that two major truck manufacturers are now actually starting to cooperate to build an electric charging network for trucks. And I think also in the telecom sector, you actually see network sharing agreements, which essentially amount to the same thing, right? It's sharing infrastructure, but then supply services independently and in competition with each other. So maybe this is the way to go. I think the issue there is, I think, at least in shipping, that what we now see is that there is not yet a common view on what the future looks like in terms of fuel sources, and that different shipping lines now make different decisions on this. But I think building a joint infrastructure could be very well a practical and interesting example of where cooperation could be beneficial.
Yes, and I think that also leads in, because you just mentioned two industries which have grappled or are beginning to grapple with, and in the case of telecoms have been grappling for many years with these kind of problems. And one of the answers to the lack of direct cases and direct guidance, etc., is, I think, that the lawyers and regulators need to be much more prepared to look at analogies with things that have been done in other industries and other sectors, where the underlying issues are very the same. To build on that experience, it seems to me is a no-brainer. And again, starting with situations that are clearly analogous and where there is a track of regulation / competition decisions, it would give everybody more comfort as to how to start to tackle this. Because the problem, one of the issues that Matthijs and I were discussing is that infrastructure seems to be a fundamental problem. And everyone assumes that that technology neutrality is good and et cetera, but there must be an issue of, well, do we have time and resource to run a whole load of natural experiments with all the infrastructure that they require to work out which is the best solution on a neutral basis? And it seems to me that it's at least worth thinking about that, because we don't have enormous amounts of time, given the time it takes to build vessels and the vessel life. The actual, I'm sure the people who finance ships would much prefer to be told, look, it's going to have to be hydrogen. Yeah, let's go with hydrogen, and then everyone knows where they are. So in some ways, the market can be, in the short term, very inefficient at using resources compared with a central directive which says use X. It is at least an aspect of the debate. But if we are going to have that kind of, what Jim Corbett was describing yesterday is the multiple pathways with lots of R&D, lots of success stories or non-success stories, then it's probably a minimum requirement that people be allowed to join forces to run those, so that we don't have wasteful of development of individual infrastructures that support those, because almost by definition, a whole bunch of those projects are not going to be the ones that end up being adopted.
Yeah, if I may, I agree with that. And this is exactly what we had in mind, condition 3 of the exemption, the necessity to sometimes share fixed costs. Otherwise, you cannot recoup them. And yeah, this is the type of example that we had in mind when we put in that condition. Sometimes you need to combine volumes and you need a joint effort. Otherwise, an action or an investment will simply not happen.
Excellent. So I'm just going to check into the chat that's going on to see if I can see some questions, because I've just been told we've got 8 minutes left, and so one issue that's been raised by Francesco Minari is, can you have regulation as a solution to the fact that it's going to be difficult to get some very extensive horizontal cooperation agreements in place? So in other words, I think you said one of the reasons why people don't like competition or private action is that it might slow down or indeed mean that regulation doesn't occur. But this would push in the other direction. This would be people saying, look, if you're going to be very traditionalist about competition law, we're telling you now, we can't see a way of doing the things we think need to be done by us. So over to you, regulators, you need to regulate, because otherwise nothing's going to happen. And it is sometimes the case that you need a well-publicized failure to get action. We have a class action regime in the UK for competition claims, largely as a result of a famous case, cargo case, where it was demonstrated by an unknown lawyer called Mr. Murray that there was a huge gap in the system in the UK for collective actions. So failing that litigation was strategically successful because it led to legislative change. And it may be that people have to be brave enough to court failure in order to demonstrate that they're willing to act, but that the framework and the mechanisms and the willingness isn't there.
Yeah, again, I agree with those notions. Competition law can only do so much. We have to be here modest. I mean, in the bigger scheme of things, it's likely to only be able to provide a small contribution. And even, sometimes we cannot even have a small contribution, and it's really up to regulation. Generally speaking, what you want is the most efficient type of government action that is possible, and competition law is meant for competition and less for other purposes. So it's natural to think that there are better government measures possible. If we can demonstrate that competition law is not able to make a substantial contribution, then it can put the pressure on other stuff. That's I can see that.
So then I think that goes back to this point, which is whether people can be given some comfort that actually talking and how the exchanges can be done won't itself, given on the assumption that there is a bona fide environmental objective, that talking won't itself cause a problem. I mean, going to the whole stuff about information exchange, I can easily see that if you wanted to analyze this kind of exchange in a risk-averse way, you would say, yes, this is absolutely future strategically important information about how we're going to power our ships, the costs, the common costs involved in that, et cetera, I can see someone saying, well, we can't really get in a room and talk about this stuff. And yet that's precisely what's needed to be done. And, that perhaps the point is that the industry needs to have a sort of really good multidisciplinary approach to the various parts of government at all levels, technical, policy, and legal, to get people to accept that, there is some good faith here. That I think is, and that may be an issue for shipping, in that that such industries have a richer history of doing things which competition authorities tend not to approve of than others, and that's also an issue. Well, I'm told that we now have 2 minutes left. I think, picked up the questions we have on the system. So I'm going to put this to a close. I mean, thank you so much, Theon, for your contribution, for staying with us, for answering unfair questions. And sorry about that. And also to Matthijs, whose firm RBB have generously sponsored these 2 webinars. I have found them incredibly interesting to prepare for and to be involved with. They are part of a series of events that EMLO are putting on. This being recorded for the first time, and the recording will be made available. We've got events coming up in September and in October on whistleblowing, on trade, and absolutely encourage people to join EMLO, because we are a not-for-profit. This is all being done for free. We rely on sponsorship at the moment because we can't hold paid-for conferences, which is our normal way of raising money. So I am also the treasurer. So I have a very personal interest in the amount of money that comes into the account rather than going out. So we need your help and your interest, and I hope this has been something of interest. Any feedback that you could give us would be fantastic. And thank you all so much.